folks? Okay, time on. I welcome members to the 31st meeting in 2013 of the Delegated Powers and Law Reform Committee. As always, ask members to switch off mobile phones. Agenda item 1 is a decision on taking business in private. It's proposed that the committee takes items 6 and 7 in private. Item 6 is consideration of the committee's draft report on the Procurement Reform Scotland Bill, and item 7 is consideration of the paper on the committee's scrutiny role. Does the committee agree to take those in private, please? Thank you. Agenda item 2 is instruments subject to negative procedure. The Water, Environment, Shellfish, Water Protected Areas, Environmental Objectives, etc. Scotland Regulations 2013, SSI 2013-325. Regulations 8 and 9 make reference to relevant enactments. The Scottish Government has confirmed that the expression relevant enactments in Regulation 9 is intended to impose duties on the Scottish ministers and SEPA when when exercising their functions under the relevant enactments by reference to a specific technical definition found in Section 2.8 of the Water, Environment and Water Services Scotland Act 2003 and SSI 2011-368. These functions include functions under Part 1 of the 2003 Act. The Government relies on a general rule of interpretation to attract that meaning rather than explicitly setting this out in the regulations. By contrast, the Government intends the expression in exercise of powers conferred by the 2003 Act or any other relevant enactment not to be restricted by the list of relevant enactments set out in SSI 2011-368, which along with Part 1 of the 2003 Act make up the relevant enactments. This use of the term is to refer to its ordinary, non-specific meaning of any enactment that is relevant. Again, the regulations do not explicitly provide for this. The committee may therefore consider that where an expression is, or two closely related expressions are, intended to make different meanings within an instrument, and this should surely be clearly and explicitly expressed. Does the committee therefore agree to draw the instrument to the attention of the Parliament under ground H, as the meaning of the instrument could be clearer? Mike.
Convener, I would like to just comment that I would be willing to accept the Government's explanation were it the case that legislation was only ever intended to be read by lawyers and members of the legal profession. However, I think there's an important principle that it should be accessible and comprehensible to lay people, and that the committee should always strive for clarity and hopefully impress upon the lead committee and government that they also should strive for clarity.
Indeed. And I think the committee is absolutely inclined to agree with you there, and really what it means should be pretty explicit on the face of it, unless it's clear that some statutory interpretation applies. Yes, so we are agreed to report that. Thank you. No points have been raised by our legal advisers on the Water, Environment, River Basin Management Planning Further Provisions Scotland Regulations 2013 SSI 2013-323, nor on the Water, Environment, Shellfish, Water Protected Areas Designation Scotland Order 2013 SSI 2013-324, nor on the Food Safety, Food Hygiene and Official Controls Sprouting Seeds Scotland Regulations 2013 SSI 2013-333, nor on the Adoption Recognition of Overseas Adoptions Scotland Amendment Regulations 2013 SSI 2013-335, nor on the Food Miscellaneous Amendments Scotland Regulations 2013 SSI 2013-336. Is the committee content with these, please? Thank you. Agenda item 3, instruments not subject to any parliamentary procedure. The Long Leases Scotland Act 2012, Commencement Number 1, Order 2013, SSI 2013-322. The instrument commences paragraphs 3.2 to 4 of the schedule to the Long Leases Scotland Act 2012 on the 28th of November 2013. These provisions amend the Title Conditions Scotland Act 2003. However, the instrument does not bring paragraph 3.1 into force on the same date. Paragraph 3.1 provides that the 2003 Act is to be amended in accordance with that paragraph. Instead, the instrument will commence paragraph 3.1 on the 21st of February 2014. Whilst such drafting is not considered defective, the commencement of paragraph 3.1 on the 28th of November 2013 would have been appropriate in order to exclude any doubt as to whether the commencement of paragraphs 3.2 to 4 could be properly interpreted as amending the 2003 Act with effect from that date. Now, the Scottish Government has committed to reviewing their drafting guidance in light of the repetition of this error, which was previously repeated in relation to Post 16 Education Scotland Act 2013 Commencement Number 1 Order, 2013 SSI 2013-281. Does the committee agree to draw this instrument to the attention of the Parliament under the general reporting ground as it fails to commence paragraph 3.1 of the schedule to the Long Leases Scotland Act 2012 on the 28th of November 2013? Thank you. Does the committee agree to welcome the Scottish Government's commitment to review their drafting guidance in the light of the repetition of this error? We do. Thank you. John.
I'd like to welcome the Government's commitment to reviewing their drafting guidance, given that this is not the first time this same mistake has happened. And I would have thought that would have been the first thing that would have been checked up on by those who do the drafting, that they didn't make the same mistake twice, given that this has been sent back to them previously. So I welcome the Government's commitment very much to reviewing their drafting procedure.
Thank you for those comments. That moves us to agenda item 4, Defective and Dangerous Buildings, Recovery of Expenses Scotland Bill. The purpose of this item is for the committee to consider the delegated powers in the Defective and Dangerous Buildings, Recovery of Expenses Scotland Bill at stage 1. In considering the bill, the committee is invited to agree the questions it wishes to raise with the member in charge on the delegated powers in the bill. It's suggested that these questions are raised in written correspondence. The responses received will help to inform a draft report on the bill, which the committee will consider at a later date. The bill inserts a new Schedule 5A into the Building Scotland Act 2003, which specifies the content of both charging orders and discharges of charging orders. The schedule provides that a charging order must contain certain information, including the postal address of the building to be charged, the name and address of the local authority making the order, the repayment amount and the amount of the annual instalment due under the order. The inserted section 46A2 to the 2003 Act provides that, unless otherwise required by an order made under section 46A3, a charging order is to be in such form as the local authority may determine to give effect to and state the information required by Schedule 5A. Section 46A3 provides that the Scottish Ministers may by order specify the form which charging orders and discharges of charging orders are to take. Does the committee agree to ask the member in charge the following 3 questions for information for further explanation as to the manner in which this power is to be exercised, in particular whether it is expected that ministers will use the power to amend the terms of the new Schedule 5A to the Building Scotland Act 2003, and lastly, if it is expected that the power will be used to make textual amendments to primary legislation, why the negative procedure is considered to afford the appropriate level of scrutiny over the exercise of this power. Are we agreed? We are, thank you. Agenda item 5, the Victims and Witnesses Scotland Bill. This item of business is consideration of the delegated powers provisions in this bill after stage 2. Members will have noted that the Scottish Government has provided a supplementary delegated powers memorandum and will have seen the briefing paper. Stage 3 consideration of the bill is due to take place on Thursday the 12th of December. The deadline for lodging amendments is 4:30 on this Friday the 6th of December. The committee may therefore wish to agree its conclusions today. Does the committee agree to report that it is content with the provisions in the bill, which has been amended at stage 2 to insert or substantially alter the provisions conferring powers to make subordinate legislation? Are we agreed? We are. Thank you very much. At which point I move the meeting into private.